I would like to welcome you to our panel discussion on racial justice in America. We are going to be addressing an issue that, as you know, is one of the burning issues in America right now. And we're going to be addressing it from the standpoint of Hispanics, African Americans, Asian Americans, Native Americans, and Muslim Americans. The title of our program is "Give Me Your Tired, Your Poor, and Huddled Masses Yearning to Be Free." As many of you know, most of you know, that is the inscription on the Statue of Liberty. And that is a guiding principle. It's supposed to be the guiding principle of our country. Perhaps after our discussion, you can make your own determination as to whether America is meeting that promise, if things need to be done, and if so, what, and how you can help in this justice movement, so to speak. I'm Richard Pena. I'm chair of the sponsoring organization, the Commission on Hispanic Legal Rights and Responsibilities of the ABA. We have some co-sponsors I'd like to recognize before we go any further. ABA section on Civil Rights and Social Justice, the ABA Commission on Women in the Profession, the ABA Coalition on Racial and Ethnic Justice, and the ABA Council on Diversity and Education in the pipeline. We're really fortunate to be able to bring you the 5 speakers today in the next hour and a half. You're going to learn, hopefully, from the best in their areas. I call them the all-star team. Some are nationally known, all are highly respected in their area and throughout the nation. And I feel very fortunate that they have agreed to be on the panel. But before we go any further, it's my great pleasure to bring you ABA President Judy Perry Martinez. And Judy, in advance, I would like to thank you for taking time from your busy schedule to talk to us, to be with us today, and to share some of your thoughts with us.
Well, thank you, Richard, so much. And I'm honored to join all of you today for this critically important discussion on racial justice in America. And I want to thank the ABA Commission on Hispanic Legal Rights and Responsibilities and all the sponsors who are here with us today hosting and co-sponsoring this important dialogue. It's good to have a discussion that brings us together as a community of diverse perspectives, diversity of race and gender and organizations, as this will take each and every one of us to have an honest, and sometimes it will be a very difficult conversation and discourse about what needs to be done so we can move forward as a nation and become a better nation. There is still so much pain and anguish, and for many, unanswered questions as to why our country is still plagued by deep-seated hatred and racism. Deprivation of civil rights and basic human rights for people of color cannot be the norm, and we cannot accept it as such, but we must join together in order to demand racial equity and dignity for all. The title of this webinar is so telling. It points to an undeniable reality that despite progress for many persons of color, there has been little release from the economic and societal chains of repression and slavery, just a shift in the type of repression and slavery. And we must end that destructive cycle. Human dignity compels all of us to spend not one more moment in silence. And we must not only speak against what we see and hear, but we must act to right unjust laws and their effects. Centuries of systemic racism will not likely be erased or remedied overnight. However, as the lawyers of our nation, we have a responsibility to address these injustices and racial inequities that continue to poison our society and justice system today. The ABA is intentionally and particularly focused on our intensified efforts to address qualified immunity for police brutality and violence. We're bringing to our House of Delegates resolutions that, if adopted in early August, will establish ABA policies that will call for independent prosecutions of police lethality, look at and promote a standard of objective, reasonable, and necessity to establish excessive force as a defense, urge a national database on law enforcement discipline, and calls for laws that prohibit chokeholds and more. The House of Delegates meets in the very first days of August. In addition to our focus on policy, the ABA wants lawyers to have ready tools for access to resources. We have launched a website, Racial Equity in the Justice System. It includes a wealth of resources for members, the legal profession, and the public on a range of issues addressing bias and racism and prejudice in the justice system and society. The website will be updated frequently to reflect growing content that we're pulling from all over the association. And we hope you'll refer to the website and use it, because we each have a contribution that we can make toward justice and equality, each of us as individual lawyers. The discussion ahead with this exceptional panel will candidly address these sensitive issues of racial equity and equal justice for all. So I thank all of the speakers who have gathered here today. Their experience and their expertise will bring forth for all of us here critical perspectives that we need to hear, we need to listen to right now. And we cannot wait another moment to hear from them, because we all need to realize what role we play in true freedom in our country. Thank you very, very much. And I look forward, Richard, to hearing from you and the rest of the panel.
Judy, and thank you. Thank you for agreeing to be with us this morning. And to those who have registered, I can tell you, I've known Judy for a long time, and it goes way back before she was nationally known. And ever since I've known her, she has been fighting for equal justice for all. So those words are not hollow. I mean, she really means it. And the ABA really means it. The ABA is completely on board for equal justice for all, and it's doing everything it can to promote that. And we as lawyers have a duty and responsibility to not only each other, but to society, to shoulder and to pick up that mantle. Now, I am gonna do a couple of housekeeping things before we get into the first speaker will be Tom Sines. But at the bottom of your screen, you'll see a Q&A and chat. Now, we encourage you, if you have any questions for any speaker, please use the Q&A and leave it specifically for the speaker if you have questions. We are in a time limit, but if we have time, we will get to those questions after their presentations. Also, you will be emailed, everybody that registered will be emailed information with how to get a video of the presentations, so that we encourage you to share it. Share it with your group, share it with your friends, share it with your family. We want to disseminate our discussion on racial justice in America as widely as possible. And with that, I'm going to go into the first speaker. And Tom Sines is the first speaker. Tom is well known to many people. He is someone who is sought after to speak often. He's the president and general counsel of MALDEF, a Mexican American Legal Defense and Education Fund. He is the lead counsel for MALDEF on numerous cases involving Latinos, including civil rights and voting. He's argued before the U.S. Supreme Court, in particular, U.S. versus Texas, and he defended Obama administration deferred action initiative. He's a graduate of Yale College and Yale Law School. He's clerked for 2 federal judges. He was a 2013 recipient of the ABA Spirit of Excellence Award given by the Commission on Ethnic and Racial Diversity. And he is, importantly, he is a member of our Hispanic Commission. At that, I give you Tom Sines.
Thank you, Richard. And thank you everyone for attending, and thank you to the ABA and the Commission on Hispanic Legal Rights and Responsibilities for convening this important program. And I do want to particularly thank both Judy and you, Richard, for your leadership in your positions at the ABA as we confront this challenging time in America. I have a short period of time to discuss the salient issues for the Latino community in racial justice, but I feel compelled to begin with some history for two reasons. At this particular historical moment in our nation's development, it seems appropriate to review some of the history of the major racial minority groups in our nation. And I do want to do that for the Latino community, but it's also important for us to confront and basically debunk two far too prevalent erroneous views about the Latino community, namely an erroneous view that we are entirely made up of recent immigrants to this country, and second, a conclusion by too many, including unfortunately some of our former Supreme Court justices, that discrimination faced by the Latino community should be viewed as exactly the same as the discrimination faced by European immigrant groups in the early 20th century. I think it's important then to begin with this origin story and for all of us to understand that Latinos were first introduced to the United States in significant numbers in the middle of the 19th century as a result of Manifest Destiny, the US-Mexico War, and the annexations of Texas and the southwestern United States. Now that introduction of Latinos in significant numbers to our country came then as a result of conquest. It was therefore accompanied by a nationwide campaign, sanctioned if not delivered by the government, to convince everyone in this country that Mexicans were of a different racial type, that they were inferior, that they were savage, calling on the part Native American ancestry of most Mexicans. So it was a racialized narrative to justify conquest of a people for a nation whose founding principles were about folks being able to decide for themselves who would govern them. And clearly conquest, Manifest Destiny, and those annexations were inconsistent. So a racialized narrative was created and propagated to depict Mexican Americans and more broadly Latinos as racially inferior. A similar story could be told about the annexation of Puerto Rico as a result of the Spanish-American War some half century later. And if you talk about then the racial stereotyping of Mexican Americans and Puerto Rican Americans, you are talking about the two largest components of the Latino community. So it's important to understand both that Latinos have been present in this country in significant numbers since the middle of the 19th century. And it is indeed true that we have had significant waves of further immigration from Latin America, from Mexico and other countries, beginning particularly in the early part of the 20th century as a result of the upheaval that occasioned the Mexican Revolution, and continuing into the 80s, 90s, and even today. So while there has been significant immigration, and therefore often immigration is an issue that is identified as belonging, if you will, to the Latino community, it's important to recognize that the Latino community has been a part of our country for a very long time and has been subjected to racial stereotyping for a very long time. Now, it's therefore ironic to understand that in the context of the legal system, that racialized narrative was actually reversed to be used against the Latino community. And therefore, I would like to remind those who remember it and those who are not familiar with it of the case of Hernandez versus Texas, which is actually the first major case to go to the United States Supreme Court involving Latino civil rights. It went to the Supreme Court in 1954 and was coincidentally decided the very same month as Brown versus Board of Education. Now, in Hernandez versus Texas, the main contention of the state of Texas was based on their view, or the state of Texas's formal view, that Latinos, Mexican Americans were part of the white race. Why did Texas adopt that view? It seems clear from the historical record it was in order to make the kind of argument that it made in Hernandez versus Texas. Namely, the state contended that because Mexican Americans were part of the white race, they could not use the precedent from the African American community in Norris versus Alabama to challenge ongoing complete exclusion from juries in South Texas. Namely, state of Texas argued that Latino defendant cannot argue that his rights have been violated because he is from the white race, and lo and behold, his entire jury is made up of members of the white race. Of course, none of them were Latino. Now, fortunately, in 1954, the same unanimous Supreme Court that decided Brown also concluded in Hernandez versus Texas that that argument would not prevail, that in fact, if you treat a group as a separate race, as a separate group, that they can call upon civil rights precedent to challenge discrimination. Fast forward to today. It's important to recognize that Latinos are now, and indeed have been according to the Census Bureau for 17 years, the largest minority group in the country. That means for some, I would characterize it as being the second largest after white European Americans, the second largest racial ethnic group in our population. We've had that status for 17 years. But a further measure of how that will change in the future is this statistic. Currently, 1 in 4 public school students nationwide, kindergarten through 12th grade, is Latino. And the proportion of preschool age students is even higher. That means that in the future, Latinos will be an even greater component of our school population and eventually our workforce. It's important to keep that in mind, I believe, as we look at what we face today, which for the Latino community is frankly, despite that long history of being in this country and that long history of a racialized narrative designed to depict Latinos as inferior, it is still important to note that we currently face what is the most overtly anti-Latino presidential administration in our entire history. Now that began roughly 5 years ago in June of 2015, when Donald Trump launched his presidential campaign after the now notorious escalator ride with a slur against all Mexican immigrants. You will recall he characterized Mexican immigrants as criminals, rapists, and he did concede that probably some of us were good people. Now, a year later, in June of 2016, he doubled down on that theme, if you will recall, by in the justice system, accusing a sitting federal judge of being biased against him. Why? Simply because that judge is Mexican American. Now that has continued as the administration took office and through its entire first term with an ongoing drumbeat of anti-immigrant statements, rhetoric, and policies that more often than not seem to clearly target the large component of our immigrant population that is Latino. That means that we face real challenges today. And at MALDEF, the organization I've had the great honor of heading for the last 11 years, the Mexican American Legal Defense and Education Fund, a now 52-year-old national civil rights organization whose mission is to protect and promote the civil rights of all Latinos living in the United States, we daily grapple with instances of explicit and implicit discrimination against the Latino community in education, in employment, in voting, and in numerous other areas of life, including housing and police community relations. Those ongoing issues of discrimination are, as often as not, made more and more explicit and tied more and more to the kind of national rhetoric we see being repeated today by some of our leaders, kind of rhetoric we may not have seen so explicitly and overtly expressed from national leadership since the middle 19th century that I described earlier, when it was viewed as necessary to justify the conquest of a people and entire territories that now make up a significant part of our United States. That ongoing discrimination, though, also resonates less explicitly in our ongoing exclusion from so many important positions in this country. We begin with the fact that at present, the Cabinet of the United States has not a single Latino or Latina member. Now, Latinos are the only major racial ethnic group of significant size not represented in the cabinet today. And you would have to go back decades, over 30 years, to find another time when this population was not represented in the cabinet of the United States. And you'd have to go back even further to find a time when the current largest racial minority group in the country was not represented in the cabinet of the United States. Now, this is as a result of the resignation of Alex Acosta as labor secretary. But it's important to remember that prior to Alex Acosta being nominated to labor secretary, the original cabinet created by Donald Trump also included not a single Latino or Latina. The only reason Alex Acosta ended up joining the cabinet is because of the withdrawal of Andrew Puzder, the first nominee to be labor secretary. Another instance of exclusion under this administration is in this statistic. Out of a record-breaking number of nominations to our federal courts, At this point, the Trump administration has managed to nominate exactly one Latino or Latina to any court of appeals in the entire country, that to the 11th Circuit Court of Appeals. The result of that exclusion is that the 5th Circuit, where the state of Texas is dominant, a state whose population is now 40% Latino, there now sit not a single Latino or Latina judge in active duty on the 5th Circuit. Now that exclusion is not, of course, consigned only to the federal government. The reason that a major candidate was able to build his campaign from day one in June 2015, as I indicated, around hostility toward the Latino community, he didn't come up with that on his own. We've seen it previously. I will remind us that this year, or actually last year, is the 25th anniversary of Proposition 187 in my home state of California, the most populous state in the nation, a state that, like Texas today, has a population that's 40% Latino. But with a growing Latino population a quarter century ago, we had a governor, Pete Wilson, who built his reelection campaign out of an anti-immigrant measure, Proposition 187, that grew to nationwide notoriety. And that targeting of immigrants more or less focused on the Latino immigrant community. This year is the 10th anniversary of SB 1070, an equally notorious nationally piece of legislation out of the state of Arizona with a growing Latino community that targeted the immigrant community, again, more or less focusing on Latino immigrants. So we have seen this pattern of using the Mexican-American Latino population as a scapegoat for some who seek immediate political gain. As we've seen in the changes in California, it often has long-term separate consequences not intended by those who exploit this concern, hostility about the demographic growth of the Latino community for their own immediate political gain. But we've seen it before. And a lot of it depends on the exclusion of Latinos from the sight and the minds of too many people in the country. Because there's a vacuum about our community. It's filled by political leaders like Donald Trump to create a negative narrative about the community that then leads to exclusion, further exclusion and discrimination. I end then by saying that that exclusion in important areas like the media is what contributes to enabling someone like Donald Trump to build a campaign out of an anti-Latino narrative. I'll give you one example of that exclusion before I end. When you look at media, whether that's movies in the cinema or broadcast television or increasingly online video content, the group that shows the largest gap between its representation in the total population and its representation on the screen is the Latino community. Here's one example of that. As I indicated, Latinos are now greater than 1 in 6 of all Americans. Census Bureau 10 years ago identified the Latino population as 16%. It's now grown to closer to 18%, and the 2020 census will give us an even more accurate indication of the growth of the population. But despite constituting 18% of the total US population, Latinos are represented in movies shown in screens across the country at about 2 to 3% of the major roles in front of the camera. We see that in other areas of life, and that exclusion contributes to the ability of unscrupulous leaders like Donald Trump to build campaigns, successful presidential campaigns, in part around an anti-Latino narrative, with consequences for ongoing discrimination and racial injustice faced by our community.
Tom, thank you very much. That's a very sobering presentation, but very needed at this time. I think it's important for all of us to go back in history, not only for the Latinos and Hispanics, but for all racial groups. Next, we have the honor of having Lisa Tatum present to us. Lisa is the past president of the State Bar of Texas. She was named in 2014 a super lawyer, and in 2007, a Texas Rising Star. She's a former district attorney for Bexar County in Texas, where that's the county of San Antonio. She's prosecuted over 100 cases to trial. She's the owner of the Tatum law firm. She's a mediator, and her firm represents private and nonprofit businesses. She's a graduate of Smith College and Santa Clara University School of Law. And importantly for our discussion, Lisa conducts independent investigations of police departments and other private entities. It's part of her practice. Recently, she was in my home city of Austin and wrote a report that was not very complimentary to the Austin Police, on the Austin Police Department for the City Council. Lisa is very well respected in Texas. Known Lisa for a long time, and I'm glad she's part of the panel. Lisa, it's all yours.
Thank you very much. First, I'd also like to echo the commitment that the American Bar Association and the individuals represented here have brought forth. I do appreciate that greatly. I'm going to kind of take a slightly different perspective because the faces that look like mine are the faces that you're seeing on television the most right now. So I'm going to give you just a little bit of background about myself because it's important to understand my perspective and then understand that I don't speak for the entire Black community, but for myself and for the aspects of the community that I engage in. So I come from a military household. I come from a two-parent home. Both of my parents are educators. And as has been mentioned, I've held leadership positions throughout the legal community and as well as within the community. But I mention this and I frame this because, again, the African-American experience is one that is just as broad as all of the other people of color. We don't have the same pathway. We don't experience things the same way. But one of the things that we do find that we have in common in our threads and our walks is that we are all finding ourselves negatively impacted by the systemic racism. So let me give you my definition of systemic racism so you understand where I'm operating from and how it is that the independent investigations that I conduct are looked at from this lens. So systemic racism for me, or institutional racism, is about an understanding of a concept or mindset of, in this case, white supremacy, that is inculcated and is rooted in everyday aspects of life and thinking within a system or within an operation on a system and operational level. So we're not talking about a one-on-one instance where there may be just the encounter. That my mother had to scoop me away from people who were throwing rocks at me because I was Black, or the compliment that many of us get of, well, you speak so well, or the individual encounter of walking through the store and being followed by somebody and monitored, but more the collective aspect of that, in that all of us are experiencing these different levels of microaggressions over the course of every one of the days of our lives, because of the result of this mindset overlay that exists throughout an entire system or operation. So that is your hiring, that is compensation, that is lending, that is education, that is healthcare, that is investigations and policing, that's sentencing. These different aspects that can come into play, whether it's profiling, whether it's access, whether it's wage disparity. And at the basal level, we're talking about the law itself. So as Tom had referred, we come from these different places in our fabric of our American society that are rooted in this concept of white supremacy. So Blacks were chattel. Chattel. Women, less than. Native Americans, part of my background and my heritage as well, negligible. And that's just part of what we've institutionalized when we talk about the mindset of supremacy. So Why are we talking about this today? Why is it particularly relevant now? Why are we having this conversation with such numbers of protests and calls for statues to come down? And I see this from an interest convergence principle. As long as what benefits those in power that are part of the systemic racism, as long as meeting the needs of the Black American or the people of color has an intersectionality that allows for this to be acceptable and good, then the system works. And why am I talking about that? We've been here before. This is not the first time that we're talking about this. We keep talking about it. And history has taught me that whenever there's economic distress, whenever there are concerns about shifts of power, these issues come up again, and they come up in stronger positions. The issues about statues and why we're asking that statues be brought down, not because those folks didn't have a role in history, but because when they were raised responsive to other issues in history. The Jim Crow laws, a way of making a verbal and a visual display of oppression to remind folks of their place and that they stay in it. So that's the context from which I look at systemic racism and how I look at how the institutions do this. So today, what's a little bit different? I think that one, we're seeing more. We're learning more because we have technology to talk about something that has always been happening on some level or another. Then we have this climate of COVID and an opportunity for folks to start taking some time and think about humanity, to reflect on themselves, plus the economic anxiety that's tied with being in this situation for the entire nation. And I think that we talk about the change of time and culture. Most of the time when we look at our legal trends about how our cases change our lives and change our law, is that we've got these temporal changes and temperature changes in society. And those changes here also have to do with generational aspects, in my opinion. We've got some young people who've come up and don't agree with the concept of white supremacy. And they're being more vocal. And those that are tired, and believe me, there are a lot of people in the Black community who are exhausted and tired right now of seeing lives be taken, of fighting the same fight over and over again, of being the book that other people read in order to understand this experience and why we're here. So with that understanding of how I have approached life and experienced life, I want to talk to you a little bit about how it is that I've come into the aspect of independent investigations. And they're for police departments, they are for governmental entities and private entities. They've been internal investigations as well as independent investigations. And usually when I'm called in to look at particular legal aspects and issues, but in usually three categories: independent acts, systemic behavior, whether that is workflow issues or patterns and practices, and then of course racist behavior. And in my experience, police officers are no different than the other individuals that are in society, except for this. They come from a special skill set and training that allows and affords a certain type of benefit, as well as a particular and unique type of burden. So in my experience, the majority of the officers that I've encountered in the investigations, they're doing what they're supposed to be doing the way that they're supposed to be doing it. But just like every place else, we have bad apples. We have racist thought, racist behavior. We have individual actions that can stand on their own or taint an entire bunch. And I say this because one of the things that I find that I have found in each of these layers of investigations, and not just in police departments, is that it's not unusual to have an informal leadership structure within a leadership structure. And oftentimes that group has its own agenda. Many times you may have heard the reference of, oh, well, you know, if you need X done, go see Susan, go see Jane. There's some individual who may get something done that's outside of your formal structure because they've got a political clout or weight or an ability to work operations and move through that. And that's something that I have seen in many of the investigations that I have conducted. It's those agendas that start to reveal themselves oftentimes in 4 different types of problems that I've come across. The actual application of the policies in place, whether it's selective or misapplication. A dysfunction within workflow, so there's something else that's problematically wrong. Bad policy. It's either just flat out bad, it has unintended consequences, it's been poorly thought through, and then a need to update and change because of either circumstances, technology, behaviors that have brought that about. I wish that I could say that this was a problem that was specific to law enforcement. But in looking at police department investigations, what I see is that it's that skill set, it's the discretion and the authority that comes. So when you're talking systemic racism, for me, you can have a racist mindset, you can have a superior mindset, and it be arrogant, it be asinine, but it's when you overlay it with power that it becomes a problem. We can deal with people, but people who are systematically using a mindset of white supremacy in this case and have power, that is when we find ourselves as Black Americans, as people of color, waking up every day confronted with these microaggressions. This is the component that starts to be an issue of that behavior. So when we see an officer of 18 prior incidences hold his knee to the neck of George Floyd, when we see video and footage of police abuse, brutality, excessive use of force, when we see that behavior become more and more brazen and easier to discern as just blatantly wrong and a breach of protocol or cruel, and when we see a lack of accountability, this is what's led to the outcry and the need for police reform. So I want to just kind of close with the thoughts. I don't have all the answers, but I do have some places where I think that we should be looking as it relates specifically to police reform and the concerns about overstepping boundaries. And that is when we talk about officer discipline, there are state statutes, there are collective bargaining agreements, and there are city policies that are the different 3 layers of places where conduct can be addressed, modified, corrected, and changed. So yes, there should be a conversation about national standards. And I'm grateful to hear that the ABA has continued in its force with the House of Delegates being able to look at resolutions to help influence what we do in terms of our laws and our policies across society. But we need to look at those patterns and trends on an internal level and an external level, because the problems exist not just for civilians who interact with police officers, but police officers and civilians who work within police departments as well. So I would encourage someone who wants to do something about these things to figure out how it is that you engage and get educated about your community's collective bargaining agreement, which holds a tremendous amount of power and weight and only comes upon review in certain periods of time based on that contractual standard. I ask that you look at your statutes. Look at what your state and on the national level we can look at doing that help make this imposition. There's a 180-day rule that is a look-back rule. So an officer who's been in trouble 18 times over the course of multiple years, when it's time for his discipline, there's a window of capture for accountability that's 180 days old. And depending on the CBA and depending on the practices and policies of the police department, it may be limited only to 180 days, or it may look back 2 years or some other set point in time. So you can have a chronic bad behavior. That person continue to perpetuate it because they cannot either be disciplined appropriately, or in some instances, they're terminated and then they're rehired either within that department or somewhere else in the police department because of a lack of transparency and understanding and reporting about officer conduct. Again, there are officers who are very good and want to see these reforms. There are police chiefs like Chief McManus here in San Antonio who publicly stated, CBAs are wrong, my hands are tied, there's limitations on what I can do. If people would look at what it is that can happen, maybe we can do more. So I ask that these be the places that we start looking at for making and effectuating change. National law, that collective bargaining agreement, leaning in when it's time for negotiations. The union shows up as they should, and citizens should show up and participate in committees and commissions and other aspects to help with that aspect of transparency and accountability. I think that that's probably about my time, Richard. So I will pass the torch.
Well, if I could clap, Lisa, I would. Thank you very much for that bird's eye view of the police workings and the result of some of your experiences. And thank you for what you're doing. Next, we're gonna move on to Don Tominki. Now, Don is the co-founder of the Asian Law Alliance. He's the executive director of the Asian Law Caucus in San Francisco, or has been, and the managing partner of Minami Tamiki LLP. He was, importantly, he was on the legal team of the Supreme Court case of Fred Korematsu, which in fact, his team overturned that conviction for defying removal of 120 Japanese. And I hope he touches on that a little bit because it's fascinating. I've heard him speak on it. Don is a super lawyer. He is a 2020 recipient of the ABA Spirit of Excellence Award given by the Commission on Ethnic and Racial Diversity. And I heard Don recently at the Spirit of Excellence Award, and he's very moving, very powerful. And Don, will you tell us a little bit about your life and what you see from your vantage point?
Thank you, Richard. I also want to thank Judy, Perry Martinez, Richard, you, and American Bar Association for being so important and shining a light on these, what could be more critical and important issues of the day. It's an honor really to be among these panelists. I do want to reiterate some of the definitional things that Lisa's laid out, and Tom as well, about racism linked with power becomes institutional racism. That's a really, really important point. And regrettably, it's part of our history. I'm going to be giving my remarks from an Asian American perspective. And to help me frame that, I have a video, a 60-minute video 60-second video that I'd like to show. So I wonder if you could please roll that.
We cannot walk alone. We must make the pledge that we shall always march ahead.
We want justice for Black families.
Because they marched, America became more free and more fair. Not just for African Americans, but for women and Latinos, Asians and Native Americans. America changed for you and for me.
No justice, no peace. No justice, no peace. No justice, no peace. No justice, no peace. I can't breathe. I can't breathe. I can't breathe. I can't breathe.
No, we are not satisfied, and we will not be satisfied until justice rolls down like waters and righteousness like a mighty stream.
As that video depicts, Asian Americans owe a great debt to the Black Civil Rights Movement, which opened the doors through which we walked through. Prior to immigration reform in 1965, replacing racist quotas with a policy of family reunification and of a skills-based preference system, the 19th and early 20th century, sort of much of which Tom covered, for Asian Americans was characterized by them working as laborers, regarded as the yellow peril, and often on the receiving end of horrendous acts of racial violence. Thanks to the Black Civil Rights Movement, post-1965 Asian American immigrants were spared some of the most ultra-racist periods of our nation's history. In the 1960s, when the Black Power movement gained momentum, detractors sought to delegitimize this movement by saying Asians have experienced racism in this country, but because of hard work, they've been able to pull themselves up by their bootstraps. So why can't you? Thus, the characterization of Asian Americans as the model minority was born. I recall in the early 1970s when the running joke was, if you're white, you're right. If you're yellow, you're mellow. If you're brown, stick around. If you're black, stay back. And if you're red, you're dead. The Asian American model minority myth had a number of consequences. It created opportunities for Asian Americans that were denied to other peoples of color, but it also made our own struggles with racial injustice invisible. And it drove a wedge between the Asian American community and other communities of color. As author activist Helen Zia has noted, if there is a good minority, that is Asian Americans, then there must be a bad minority, i.e. Black, brown, and indigenous peoples of color. Our own history as Asian Americans teaches us that in a culture of racism, how easily Asian Americans could be and have been vilified. Kevin Shee, a prominent Asian American attorney who grew up in Houston's 3rd Ward, the birthplace of George Floyd, noted, "We can't change the way we look. And if we are targeted, your model minority image will not save you." She's right. You don't have to convince Japanese Americans who are incarcerated en masse merely because they happen to look like the enemy of the truth of that statement. You don't have to convince the family of Vincent Chin, the Chinese American murdered and beaten to death because he was mistaken to be Japanese and responsible for the unemployed auto workers that took his life. And you certainly don't have to convince the 1,000 or so Asian Americans who were attacked after the president called the pandemic the Chinese virus and labeled it Kung Flu. While injustice suffered by Asian Americans due to systemic racism is certainly different in degree and manner from other communities of color. For example, 400 years of slavery and de jure and de facto segregation stands alone for its sheer cruelty and inhumanity. Racial injustice and bigotry against any community emanates from the same system. Systemic racism is really, and this is the power dynamic that I think Lisa and Tom were talking about. It's part of a playbook that tyrants and supremacists have used since time immemorial to hold power by shaping a nation's ethos and culture. In the United States, this is done by purporting to define who is an American and who is not, who belongs here and who doesn't. There are 3 elements to this playbook: appeal to prejudice, fearmonger and scapegoat, and traffic in alternative facts, conspiracy theories, and falsehoods. Here's one example of this playbook in action using Asian American history. In 1942, General John L. DeWitt declared the Japanese race is an enemy race. Well, that was the conspiracy theory then. But the political goal of the rhetoric of racism was removal and incarceration, urged on by farming interests who viewed Japanese Americans as competition, and by budding politicians, including Earl Warren, the Chief Justice of the United States, who built their careers by vilifying our community. Now, Fred Korematsu defied the orders rounding up Japanese Americans. He was arrested and convicted. He appealed. The government defended against his Supreme Court challenge by claiming the Japanese Americans were spying. To Fred's surprise, in 1944, he lost. 37 years later, Department of Justice memos and official reports surfaced, revealing that the Navy, the FBI, and the FCC had categorically refuted all of the claims of the Army and concluded that Japanese Americans had done no wrong, posed no threat, and that there was no reason to lock up this population, and that the Army's claims were, quote, intentional falsehoods. But so powerful was this culture of prejudice, the belief that Japanese Americans were an enemy race that didn't belong here, that despite the protests from high officials in the Justice Department who were whistleblowers, that the government had a duty not to lie to the court. The Solicitor General stood by the Army's claims, knowing them to be false, and suppressed evidence in order to manipulate the outcome of the Korematsu decision. For the court's part, it abdicated its traditional role as a check and balance on the abuse of power by the executive branch. It asked no questions, essentially reasoning to its everlasting shame. If the government tells us that the mass incarceration of Japanese Americans makes the nation safer, then who are we to question the government? In the 1980s, when we were able to throw out Fred Korematsu's criminal conviction for refusing to comply with the mass removal, little did we realize that the Korematsu case would be more relevant today than it was when we reopened the case. Fast forward, after the candidate Donald Trump called for a ban on all Muslims entering the United States and declared Islam hates us, in January 2017, President Trump issued the first of thrice revised executive orders banning travel from certain Muslim majority countries. Muslims were now in the crosshairs and characterized as terrorists to justify a ban which to this day continues to separate American families without any evidence of wrongdoing and for no tangible reason. The Korematsu lawyers joined a legal team to file an amicus brief reminding the court that in 1944, when it abdicated its role of asking probing questions and being a check and balance on the abusive power of the executive branch, it was a civil liberties disaster, demonstrating the peril to democracy when courts blindly defer to the government's unsubstantiated claims that national security justifies curtailment of fundamental freedoms. In 2018, in a 5-4 decision, the court sadly upheld the ban. Chief Justice Roberts declared, quote, Korematsu was gravely wrong the day it was decided. But in the same breath, he concluded that Korematsu has nothing to do with the travel ban and held that the court would not question the motives or judgment of the executive in matters of national security, and that Trump's anti-Muslim vitriol simply didn't matter. Well, that's more or less what the court did in Korematsu. There, Justice Black denied that the orders requiring the forced removal were based on racial prejudice. The dissenters in that case, however, pointed out that that was preposterous. You know, as lawyers, we are trained to believe that facts and the law matter. But the culture of systemic racism creates its own narrative, I think as Tom and Lisa pointed out. Its own alternative facts are fashioned, making, for example, a death sentence for driving while Black, or jogging while Black, or sleeping while Black, hardly worthy of a shrug. Where the country becomes numb to Mexicans or drug dealers and rapists, Islam hates us, where a moral equivalence is posited between Nazi marchers and those protesting them, where manifest destiny makes it okay for the genocide of Native Americans, where the press is the enemy of the people and dissenters are shouted down and whistleblowers are retaliated against. If all of these things become the norm, then the country will have descended into a very dark place where neither facts nor the Constitution matters, and democracy ceases to exist. As lawyers, we take an oath to support the Constitution and the rule of law. I think that means something. We can't be bystanders to history. We can't remain silent in the face of injustice. We need to get involved in ways big and small. I think Lisa has pointed out some of those ways. By standing in solidarity with the Black Lives Matter movement and other movements, we also stand for the ideals upon which this country is based. In my travels with Fred Korematsu before he passed, he always closed by saying to groups, don't be afraid to speak up. Let's not be afraid to speak up. Let's speak up. Our voices now are more important than ever. And in particular, for those members of the American Bar Association and members of the bar generally, I think we have a special role to be active in this historic time and place. Thank you.
Don, thank you very much for that excellent presentation, and thank you for the warnings that need to be taken seriously by everyone watching and by this country. Our next speaker is Patty Ferguson Boney. Patty's a director of the Indian Legal Program and Indian Legal Clinic of Arizona State University. She's a founder and director of Arizona Native Vote Election Protection Project. She's co-chair of the Native American Concerns Committee of the ABA Civil Rights and Social Justice. She's a former president of the National Native American Bar Association. She's the 2020 recipient of the ABA Spirit of Excellence Award that is given by the Commission of Ethnic and Racial Diversity. Patty is a leader in the Indian cause. She's a voice that needs to be heard, and she gave a great presentation at this year's Spirit of Excellence Award in Austin, Texas. Patty?
Thank you very much. I'm so honored to be part of this discussion, and I want to thank the Commission and the ABA for being a leader in this discussion, which we all know is so important. And just from the time that we've had here so far, I think we realize that our experiences are similar, although different, based on the systemic racism and the policies to justify the situations that we're in. And I just want to note, I'm giving my perspective. I'm from the Pointe-au-Chien Indian tribe, which is only one of the more than 700 tribes in the United States, but there are policies that impact all of us and tribal people. And so I just want to start with framing my discussion on something that other people have also mentioned, that invisibility perpetuates harm. And this impacts not only resources, land rights, legal rights, the justice system, our healthcare, infrastructure, education, environment, and voting, but our everyday lives. And that this systemic racism is built on a framework of laws and policies that have been codified, as has been mentioned, but also on purposefully untold or rewritten history. And so we really need to face the history in this country, and we have failed to do that thus far. This results in exclusion and the minimization of voices, and allows the continued use of negative stereotypes that justify the policies and treatments of not just Native people, but people of color. I just want to mention that these laws and policies that impact Native people, and I think as Tom mentioned, the policy of manifest destiny and conquest is all, I think, to focus on who has the power, who has the right to the resources, who has control, who has the land. And if we can dehumanize someone or a people's, then we have the power and the justification to control that land, the power and the resources. And this is, you know, obviously what happened when Europeans came to the United States and discovered people who were already here. And there was policies for that, but then this was codified by the US Supreme Court through the Marshall Trilogy and resulted in the codifying the doctrine of discovery, which focuses on the dispossession of native peoples because they're heathens and savages. And in the Supreme Court decision, Justice Marshall said that the tribes of Indians inhabiting this country were fierce savages whose occupations were war and whose subsistence was drawn chiefly from the forest. And that discovery gave an exclusive right to extinguish the Indian title of occupancy, either by purchase or by conquest. And this continued with the Supreme Court in latter years, then setting a foundation for the federal relationship with tribes, basically saying that tribes are domestic dependent nations who need guardianship, and that we have a trust responsibility to you because of this government to government relationship, but we are going to be the guardians over that, which, you know, has resulted in negative consequences for Native people, even though the court has recognized inherent sovereignty. So I just think it's important to mention that, because the guardianship relation has been used for years to deny Native people's rights in the United States. And the US took great strides to implement these racist laws and policies to rid the country of its Indian problem. There was a treaty making period that ended in 1871 that respected the government to government relationship, but it also was done in a way to set the boundaries of where Native people should be living. There were over 395 treaties that were negotiated between the tribes and the federal government, and these are considered to be the supreme law of the land. However, as some of you know, we also have a very negative history because we always want more land. We always think that Native people should not benefit from the resources of their lands or continue to live on these lands. And this period is very negative. We have the Indian removal period. Under Andrew Jackson, the Indian Removal Act was passed in 1830, and over 60,000 Indians were forced to remove. This is the different trails that Native people had to travel when they were removed, and they had to travel thousands of miles to this new territory with many thousands of Native people dying along the way. And Andrew Jackson basically justified this because white people were a superior race, and that Native people didn't have the intelligence, industry, or the moral habits which were essential for any favorable change in their condition. In addition, we had the allotment period. And so basically, for those people who weren't removed, who were put on reservations or moved to reservations or had reservation boundaries, the federal government decided that it would be better to open up access to these lands. And so this is a sign basically of Indian lands for sale, and it basically they wanted to assimilate Native Americans and have them live on parcels as white people did, and then they could maybe then become good citizens. And through this act, the Indian Allotment Act, over 90 million acres were lost for Indian people. And then in addition to that, we had the boarding school system, which was another attempt to assimilate young people. Basically, the motto for the Carlisle Indian School was to kill the Indian and save the man. And so this was a very negative. Actually, my husband's great grandpa was put in jail to try to prevent Hopi children from being taken to these boarding schools, where they basically cut their hair, gave them new names, and taught them how to be as white people. So that's a very negative period. There's also was a short period of Indian reorganization when they realized that the assimilation process was not working as they planned it to be. But then in the 1950s, we have the termination period, and over 109 tribes were terminated. But it's not really a surprise, because the person who was in charge of the Japanese internment camps became the Commissioner of Indian Affairs, and his name was Meyer, and so he pushed this Indian termination period. And at the same time they were terminating tribes, they were relocating Native people into major cities, giving them one-way bus tickets. And so that really disrupted Native life. And so it wasn't really until the civil rights period in the 60s that we moved to a period of self-determination. And that was really built on the movement in the 60s. And so I think that's important to note, is that when there's a larger movements and recognition of harms, that Native people have been involved in these movements as well. But the federal government has a trust responsibility to Native people, and they have failed to live up to this trust responsibility. Federal funding is grossly inadequate, and you can see it on all levels. Our justice systems are underfunded: education, housing, health. There are a lack of cultural protections of sacred sites and cultural heritage, a lack of treaty enforcement. We have huge infrastructure issues. I think only 10% of people in Indian country have broadband access, lack of access to mail, electricity and water, as we've seen in the COVID-19 response, that this really has huge impacts on the spread of COVID-19 when people live in close quarters and you don't have water even to wash your hands. Tribes have been stripped of criminal jurisdiction by the courts and the laws, and the federal government has failed to maintain their trust access. And this impacts our right to vote, our sacred sites, and our livelihood. And I just want to mention some statistics which you may be aware of, but Native people are 3 times more likely to be killed by police than white Americans. Native American women are 10 times more likely to be murdered and 4 times more likely to be sexually assaulted. We have some of the lowest graduation rates, high poverty rates, and our lack of plumbing is 10 times the national average. Now, you may not know some of these statistics because Native Americans are not included in a lot of the data. This is really unfortunate, because if we're not included in the data, then we're not being discussed. And this is a problem across the government, across disciplines, and it limits the ability to address problems. I want to note that recently NALP and the Center for Women in the Law did just that. They listed us as an asterisk for Native American women in law school. And this method of just having an asterisk reinforces invisibility. And I think we need to do better, because we can't raise the consciousness of Native people if we're just a footnote in society. And it also leads to a lack of cultural awareness. I want to note that the White House Initiative on American Indian and Alaska Native Education Education found that the use of Native mascots by school institutions perpetuate negative stereotypes, encourage bullying, and can harm students psychologically. The lack of accurate history about Native Americans in U.S. public education can contribute to negative stereotypes across the board. And so this plays into implicit bias and also explicit bias, and basically results in the invisibility and erasure of Native Americans in all aspects of modern US society. When people think about Native Americans, oftentimes they think about Native Americans in the past. I took the implicit association test yesterday, and all the pictures for Native Americans are historical representations. And I think that's a problem when we think about Native people or any people as set in a certain period of time, because that I think results in people not understanding the issues and leads to the issues not being addressed. And so one of the issues that the Native community has focused on is like changing the names of these mascots because they perpetuate harm on our Native people. And I think that some of you may know that Native people have been fighting for the rights against intrusion on sacred sites and protecting water. Water is life, and they've been met with a lot of resistance because of the laws and policies and not doing sufficient environmental reviews. And so a lot of people came out to support Native Americans in the No DAPL movement. And now Native Americans also want to stand in solidarity with Black Lives Matter. A lot of Native organizations have issued statements, and Native people have issued statements to stand in solidarity, because we have to support one another because the systemic racism impacts all of us. One of the things that I just want us to think about, being a Native person, is that I think that we need to recognize and respect history and recognize the lands on which we are all on. I think that we don't want to do that because that's been, subjugated through this manifest destiny. But I think that it's important. And I think until we recognize and respect this history, we're not going to be able to move forward. I think we need to continue to include voices. And as others have mentioned, when you exclude voices, that perpetuates harm. And we need to address the systemic issues in our system. And this is through our laws and policies. It could include, it's in policing, it's in reporting, it's in racism and the laws to protect sacred sites. These are honest and difficult discourses that we need to have, but we need to look at the legal framework and figure out how we can get rid of the playbook that someone mentioned, like the playbook of systemic racism. For Native people, we don't have full criminal jurisdiction over our lands, and that's one of the reasons why we have high rates of sexual violence in Indian country. But I hope that we can continue to build partnerships and promote positive changes. And again, I want to thank the ABA for taking leadership on these issues and promoting these discussions.
Patty, thank you very much for your presentation. It was extremely eye-opening for all of us and very needed. And thank you for participating. Our last speaker, Nimra Azmi. Nimra is an attorney at the Muslim Advocates Program, and she does investigations on behalf of the Muslim community. She has challenged the Muslim ban and defended prisoners' rights. She's a graduate of Harvard Law School and Barnard College. She's authored a number of civil rights articles, including one that's going to appear in the Harvard Journal sometime this year. Nimra is a rising star in the Muslim community, and we're very pleased and honored to have her. Nimra, can take it away.
I'd like to thank the ABA for hosting this panel. Thank you, Richard, for that lovely introduction, and to Judy as well for your support in elevating this really important conversation at a crucial time. And I'd love to thank the preceding panelists for your very thoughtful perspectives on really important and complicated issues. So for my piece, I want to talk about two topics. First, I want to discuss how conceptualization of racial justice that centers Black lives is inherent to any American Muslim conceptualization of racial justice. And secondly, I want to discuss how the mistreatment of Black Americans creates the architecture for the racialized mistreatment of other minorities, including Muslims. And so particularly for the second piece, there's really no clean lines. Much of the harm that falls the broader American Muslim community also falls on the Black Muslim immigrant and non-immigrant communities. And as other panelists have mentioned, I'm speaking from my own perspective. I'm an American Muslim, I'm Pakistani American, and I'm not speaking for the entirety of the Muslim experience, but drawing on my own personal experiences and my work. So first I want to talk about the history of Islam in America. Islam in America is as old as America itself. African Muslims were forcibly brought to the United States to labor as slaves on plantations and farms. And historian Sylvain Diouf estimates that approximately 30% of the African slaves brought to the Americas were in fact Muslim. And one of the many things that about themselves that these slaves were forced to abandon was their faith as part of a so-called civilizing venture of their white masters. But even in this slave context, many of the slave rebellions that occurred in the Caribbean and throughout the Americas were in fact led by Muslim slaves. And some Caribbean countries went so far as to, for time periods, banning the importation of Muslim slaves because they were seen as an inherent security risk. So we're seeing already from the very beginning of Islam in America, of the Americas, the idea of the Muslim as a security risk. Fast forwarding to the present, according to Pew, about 20% of American Muslims are Black, and conversely, 2% of American Blacks are Muslim, which is double the overall rate for the US population. And so you can see that there is a fundamental and historic intersection between Black and Muslim identities in America. So when we talk about the Black experience of racial justice, there are direct threads in which the Muslim American experience is interwoven. And so to that end, let's jump to the mid-century struggles for racial justice by Black Americans. Many of those were grounded in Islam, whether that is the Nation of Islam, which was a key part of the Black liberation movement of the 1960s, that also led to leaders like Malcolm X and Muhammad Ali, who first came to Islam through the nation before adopting more mainstream practices. And their Islamic identity was crucial in their formation of a theory of racial justice and civil rights for Black Americans. And then to the end that the idea of Black liberation was seen as antithetical to a broader American system of governance and oppression. After World War II, the FBI used the mainstream media to prosecute a war of disinformation about Muslim groups. And by the 1960s, engaged in aggressive counterintelligence to repress what it deemed to be the threat of political radicalism amongst Muslim Americans, most of whom were Black and were basically using kind of a Muslim lens on the issue of racial justice. In more recent years, many victims of high-profile police slayings have been Black Muslims. And so if you guys might remember, Stefan Clark, who in 2018 was shot by 20 rounds in his grandmother's backyard while talking on the phone. He was Muslim, he was Black. Cops claimed that he pointed a gun at them, although they found no gun on him. And then in 2019, the Sacramento DA announced that the cops who killed him would not be charged since they had probable cause and were legally justified in using deadly force. A little bit before that, in 1999, the New York police murdered Amadou Diallo, an unarmed Black man, a Muslim and recent immigrant, outside of his own apartment. Police fired 41 shots at Diallo without warning and without cause. No officers were convicted. One of the police officers involved had previously killed a Black man who was also unarmed in 2015, so approximately 16 years later, and then was then promoted to sergeant. And so you can see how Black Muslim bodies are a crucial site of the current struggle for racial justice in the policing context. And then sort of on the other side of the question of policing, according to a Muslim advocate study, 9% of the American prison population is Muslim, and there's a high intersection between the Muslim population in prison and the Black population in prison. And the carceral system is inherently a racist one, with roots in post-Reconstruction endeavors to deny liberty to Black Americans that were gained through the 13th Amendment. And it has continually been expanded as a tool of oppression. And so to achieve racial justice, we really need to rethink our whole prison industrial complex, by which I mean significantly reduce prison populations, decarcerate the men and women housed there, and overall rethink our justice system and the role that police play in it. And so for Black Muslims, the risks of being Black in America are an inherent part of their identity. And so any conversation around racial justice in the American Muslim community is incomplete unless it includes a discussion of how to achieve racial justice for Black Americans as a whole. And then so we can also jump then to the racialization of the American Muslim, particularly in the context of the war on terror. And so earlier I provided a little bit of data on kind of the Black Muslim demographics in the United States. More broadly speaking, overall, the Muslim population is 1.1% of the United States. About 58%, according to Pew, are immigrants. 41% identify as Asian, 48% identify as white, which also includes like Arabs and Iranians, because under the census, there isn't a MENA category, there isn't a Middle Eastern, North African category, they're all lumped under white. And so that skews the data a little bit. And in the aftermath of 9/11, we saw apparatuses of state violence like police and prisons be deployed against the American Muslim community, particularly the immigrant, South Asian, Arab, Muslim community. And so these systems that were built up to oppress Black Americans were then deployed against a newfound created enemy of the state. So for example, soon after 9/11, about 762 brown, Muslim, and Arab non-citizen men were rounded up and detained and held without cause by the government. And while they were detained, they had their civil rights violated. And recently there was a ruling that found that that was okay. That was fine. That we're great. We're happy that happened, essentially. Likewise, in October of 2001, the Patriot Act was passed with enhanced wiretapping and surveillance and roving wiretaps, so on and so forth. Again, targeted largely at the American Muslim community. And, you know, there's been a lot of examples, I think, recently of President Trump calling for various actions against Muslims. During his campaign, one of the things that he called for was the idea of registering Muslims, a national registry of all Muslims in America. And that was considered outlandish. However, in 2002, the US government promulgated NSEERS, which is the National Security Entry Exit registration system. And that is essentially a Muslim registry. And it required non-citizen men over the age of 16 to register at an INS office. And the countries that were included were Iran, Iraq, Libya, Sudan, Syria, Afghanistan, Algeria, Bahrain, Eritrea, Lebanon, Morocco, North Korea, Oman, Qatar, Somalia, Tunisia, UAE, Yemen, Pakistan, Saudi, Bangladesh, Egypt, Indonesia, Jordan, and Kuwait. And so you can see like that there's a very specific demographic in mind here for which countries are being targeted for this type of registration, which countries and which people and which faith group are considered to be the inherent threat that deserves to be registered in this way, whose movements and whose very presence in this country needs to be monitored for the security of the broader American public, let's say. And the registration system itself was actually only removed near the end of Obama's second term in 2016. So even under Democratic president, 8 years of Obama, NSEERS continued to be operative at that time. And so you think about the ways in which, even though we would consider maybe certain parties to have views on certain groups that are more positive, are not as racialized, or not as considered as dangerous. And yet you find that oftentimes it reverts to the mean, or it reverts to where we have been previously. Another example, I think, of the ways in which you see a real clear intersection between the ways in which you know, kind of American Muslims or Muslims and Black Americans have been harmed is Guantanamo Bay, right? It's, again, it's this indefinite detention of brown male bodies. No one has been held accountable for Guantanamo Bay. We continue to house people in Guantanamo Bay without charge, without due process, really. And I think that system of Guantanamo Bay would not be operative without, I think, a broader consensus around who we're able to dehumanize, how we dehumanize them, and the ways in which they are dehumanized, and impunity for public officials who act nominally in the interest of public safety, but instead use a bloated state apparatus to violate the rights and bodies of people of color. And another, I think, kind of more recent example, well, not that recent, but, you know, in the mid-2000s, the NYPD engaged in a rampant spying program against American Muslims. And so they sent informants into Muslim students associations, into mosques, and they mapped these communities out, and it resulted in no credible leads. But I think, you know, first, it encompasses the over-policing of minority communities, right? This conceptualization of a community as a danger and the willingness to deploy police force against that community. And secondly, even in February of 2020, so that was, you know, many years after there have been lawsuits, Muslim advocates had a lawsuit against the spying program. The spying program was disbanded. Even in February of 2020, when Mayor Bloomberg was running for office, he defended the program as the right move, as the right call, that Muslims were, in fact, you know, there were threats there. They deserved to have, you know, their houses of worship, their community organizations infiltrated. Even at the same time, he renounced stop and frisk. And so I think here there's something to think about in terms of the ways in which political actors will renounce certain actions, not because there's an actual personal belief that those actions were wrong, but that there is a political clout to be gained by denouncing those actions. And I think, you know, Mayor Bloomberg made the calculation that for the American Muslim community, he does not need to apologize for those actions of over-policing. And, you know, I think just to sort of bring it to the intersection between the Black community and Black Muslim community and the broader American Muslim community, one of the big things that happened post 9/11 was entrapment, right? And so paid FBI and police informants would go into mosques, try to induce, bully, badger, bribe Muslim attendants to commit terrorist offenses, and actively attempted to radicalize people who would most likely otherwise not have done anything at all. A big example of that was in 2009, the Newburgh Four. An informant was sent into a predominantly Black mosque in Newburgh, New York, and that informant was used by the FBI to entrap 4 Black Muslim men into plotting to fire Stinger missiles into U.S. military planes. They were impoverished men. At least one had mental issues, and the FBI used money and food, offers of $250,000 and BMWs and a trip to Puerto Rico to induce these men into agreeing to commit a plot that was instructed by the informant. Each of these men was convicted and sentenced to 25 years in prison, and the court ultimately rejected an entrapment defense. So these men are still incarcerated. And I think I'm basically out of time, but I do want to flash forward very quickly to the Trump administration. And, you know, this overall call for a shutdown of all Muslims entering the United States during his campaign, saying things like Islam hates us, saying that there are truly sick people. One of the first things he did as president was enact the Muslim ban, which continues to be in place. And so it covers Yemen, Syria, Libya, Iran, and then also small parts of Venezuela and North Korea. It was upheld by SCOTUS as a lawful exercise of the presidential power to regulate immigration, with a willful blindness to a lot of these very racist, damaging background statements, which you can contrast with how SCOTUS viewed other statements in Masterpiece Cake Shop, where it defended essentially the rights of a bakery owner to deny service to a homosexual couple because of so-called offensive statements made by the commission. In January of 2020, the president enacted Proclamation 9983, which expanded the Muslim ban to include African countries and Asian countries, each with notable Muslim populations. And so you see here a direct intersection between the Black Muslim struggle for racial dignity in this country. And so to conclude, inherently the conceptualization and pursuit of racial justice from an American Muslim perspective has to be intersectional. We are a very racially diverse group. And so for American Muslims to achieve racial justice, it has to basically look like racial justice for all Americans. And the American population cannot achieve racial justice unless we take every one of our brothers and sisters in our faith and outside of it with us.
Nirma, thank you very much for your excellent presentation, and we wish you well in what you will do in the future. I'd like to take a moment to thank our speakers for their excellent presentation. Don, Tom, Lisa, Nirma, and Patty, thank you very much. And Judy, thank you for being with us and staying with us throughout the program. And to the audience, I would like to thank you for joining us and for everything that you do and will do for racial justice. I'd like to talk to you about the Hispanic Commission a little bit. It has a lot of resources. There are a lot of webinars, and you're free to access those. Also, you should consider, if you're not a member of the American Bar Association, you should consider becoming a member. ambar.com is where you would join up. Their dues recently have been decreased. We unfortunately don't have time for questions and answers of all the panelists. The presentations I thought were excellent, but there are some takeaways. There are some takeaways that we should all have. One of the takeaways is that it was said that we come from different places, but we have wound up in the same place. Now you know why. We are one. We're not separate, but we're one. Discrimination against one is discrimination against all. It is our duty and our responsibility to speak up when there's discrimination against any racial minority or any person. We have a special duty as lawyers. This is not the time to become neutral. This is the time to speak up. The hour is getting late. The time is upon us. I would encourage this to be used as a springboard to getting all the racial minorities together and to speak up in one voice. On behalf of ABA Commission on Hispanic Legal Rights and Responsibilities and all our speakers, thank you for joining us. Right on.
Thank you.
Thank you.
Great job, Skip. Thanks.
I'm going to leave now. Skip, are you still on?